Good morning, everyone. It's a real pleasure to be here today. My name is Susie Blamire. I'm the strategic lead for safeguarding at the DBS, and I've also been a qualified social worker for the last almost 25 years. So really, really pleased to kind of make this link between our functions at DBS in this social work week. And I have with me my colleague Cathy Taylor, and I will let her introduce herself to you.
Yeah, good morning, everybody. I am Cathy Taylor and I'm acting head of partnership within the disclosure and barring organisation. So prior to working for DBS, I've worked really closely with social workers in roles such as managing a children's centre and also supporting children who've been impacted by domestic abuse. So it's really, really good to be here today. Thank you.
Fantastic. Thank you, Cathy. So for the next probably half an hour or so, Cathy is going to take us through, start with the kind of an overview of our disclosure function, and then we'll talk about how the barring process works. And I'm going to then kind of relate some of those slides more specifically to us as social workers and how we interact with them. There will be, as Renee said, a Q&A function open throughout the presentation. So if you do think of any questions as we go through, please do pop them in there and we'll do our best to answer them at the end. So a little bit about DBS. What do? We are here to protect the public by trying to help employers and those who engage volunteers to make safer recruitment and employment decisions. And we also look at barring individuals who pose a risk to vulnerable people. So those are the two key things that we do: disclosure and barring. And we often find when we're talking to people that people know about the D in DBS, but a lot less about the B, the barring. We're all familiar with those criminal record checks, but unless you've interacted with it, often a lot less is known about our barring function. And that is where we make decisions about whether individuals should be barred from working with children or from working with vulnerable adults, or both. So our aim at DBS is to be a trusted and influential organisation who provides a really outstanding quality of service to all our customers and stakeholders. We have the strategy that you can see on screen there, which helps us to develop as an organisation to improve the services we provide. And especially, we're really interested in increasing the impact and the contribution that we make within the safeguarding community. We have an excellent partnerships and outreach team that Cathy heads up that works with organisations all across the country, helping people understand the DBS functions, helping them to understand eligibility for checks, what a barring referral is and when they need to make it. And we're going to touch more on that later. So how is any of this relevant to social work? What is the intersection between the DBS and social work and social workers? As social workers, you will undergo DBS checks. Many of you will be working in what we call regulated activity, and Cathy's going to talk more about that later. You will likely have enhanced checks, usually with barred lists, and certainly well if you're working in regulated activity. So you have checks in your own right. If you are a social worker or a social work manager who manages or recruits people, you will certainly have sought and reviewed DBS checks for your staff or volunteers. You may have experience of checking our update service. The third kind of way you might interact with us is that you might be tasked with reviewing DBS checks of people that you're placing children or vulnerable adults with, for example, family members or foster carers or adopters. We're going to talk to you a lot later about the legal duty to refer to us. And if you employ people or engage volunteers, you may need to refer a person to us for barring. And that's if you terminate their employment or volunteering because of safeguarding concerns. And we're going to talk lots more about that later. You may also need to respond to a request from us in relation to barring. You may not have made the referral, but we might ask you for information. So there's lots of ways in your role that you might come across the DBS. So we think it's really, really important that you know what we do, how we can help you, and how you can help us. Because at the end of the day, we're all here for the same purpose, to prevent harm to children and to vulnerable adults. I'm now going to hand you over to Cathy, who is going to take you through our disclosure function to begin with.
Thank you, Susie. So, as you can see on the screen there, the DBS has got the functions of supporting disclosure, which are your DBS certificates for England, Wales, Jersey, Guernsey, and the Isle of Man. If a person's located in Scotland, that function is controlled by Disclosure Scotland, and if it's in Northern Ireland, that is by an organisation called Access NI. We also operate barring functions, as Susie has mentioned, for England, Wales, and Northern Ireland. And in Scotland, again, that is controlled by Disclosure Scotland. But if you are barred from regulated activity in England, Wales, and Northern Ireland, that bar would also apply in Scotland for regulated work, and vice versa, that if you are barred in Scotland to carry out regulated work, that bar would also apply for regulated activity in England, Wales, and Northern Ireland. So legislation underpins everything that we do at the Disclosure and Barring Service. We do have different pieces of legislation which govern our disclosure functions and our barring functions. And we understand that it can be really complex to understand the legislation. So this is one of the things that my team is responsible for, is we're trying to help people and organisations understand DBS legislation, how to apply it as well. So within the DBS, we can only operate because the law allows us to. The laws are set out which tell us what we must do and what we can do. So just to give you a bit of an insight about how vast the Disclosure and Barring Service is, thought I'd give you some statistics. So as you can see, over the past year, we've actually produced 5 million standard and enhanced DBS checks. We've done 2.6 million basic checks. We have 2.9 million people subscribed to the update service, and we've got over 100,000 people who are barred from working in regulated activity with children and or adults. So as you can see, there's a lot going on with DBS. So when we think about our products, we have 4 different disclosure levels of check. And as Susie said, most of you will have been having the enhanced with barred list checks because most social workers will be in regulated activity, but you might not know as much about our other levels of checks. So the first one we have is a basic DBS check, and a basic DBS check has no legislation which surrounds it, which means anybody can ask for a basic DBS check or be asked to provide a basic DBS check. And it will show you unspent convictions and conditional cautions. The next check we have is a standard DBS check. Now this has some eligibility requirements around it, because eligibility for this is set out in the Rehabilitation of Offenders Act 1974, Exceptions Order 1975. So for people who are eligible for this check, it mainly covers roles such as registering to become a barrister, people who work in the judicial court system, and those who work in healthcare but do not deliver healthcare, but they do have contact with patients. Also, if you are a member of the Fire and Rescue Service, you are also eligible for this level of check. So this will show you spent and unspent convictions and cautions, subject to what we call filtering. And I will come on to talk about filtering next, because I think it's a really important thing for people to know about. For both levels of our enhanced check, they will also show you the spent and unspent convictions and cautions subject to filtering. But our enhanced check will also show you relevant police intelligence. So relevant police intelligence is information that a chief police officer believes ought to be disclosed because of the workforce that a person is going into or a role that a person is going into. And eligibility for our enhanced checks is set out in the Police Act 1997 and the Police Act regulations. And for the most part, an enhanced check will cover people that are working closely with either children or vulnerable adults who are not tending to be in regulated activity. Our enhanced with barred list check is for those who are going to be undertaking regulated activity. So it does contain a check of the barred lists. And as we've been briefly mentioning, we do have two barred lists. We have the adults barred list and the children's barred list. And these lists contain the names of individuals who are legally not allowed to offer to work, to seek to work, or to work in regulated activity. And for people who are employers, it's actually an offence for you to knowingly employ someone who is on one or both barred list if it is linked to the workforce they're looking to work with. So although DBS checks are not mandated in law, we do say it's always best practice if you are having someone engage in regulated activity that you get an enhanced with barred list check for the relevant workforce. So as I've just mentioned, for our standard and enhanced checks, filtering rules apply. So what are filtering rules and why did we implement them? So filtering rules are when we will remove certain information from a person's DBS certificate. And that is because under law, we have been told that we must do this. So originally when DBS checks first came out, everything about a person was disclosed in terms of their convictions and cautions. And then in 2013, the Supreme Court ruled that disclosing all spent and unspent convictions was in a breach of the European Convention on Human Rights. Therefore, we started our filtering regime. And this means that some information that may be on a person's police national computer record may not appear on a person's DBS check. So, in terms of the rules, convictions are always considered individually, and a conviction will be filtered from a criminal record certificate only if 11 years have elapsed since the date of conviction, or 5.5 years if a person was under 18 when convicted. It did not result in a custodial or a suspended sentence, and it's not on the list of specified offences. So specified offences are offences that are set out in law that will always appear on a DBS check. And these are usually things that are really serious sexual offences or violent offences. When we look at cautions, a spent caution for adults will be filtered after 6 years of elapsed since the date of the caution. And again, only if it doesn't appear on that specified offences list. Spent youth cautions are not disclosed on DBS certificates. So although information may be taken off a person's certificate, if it is an enhanced certificate where it's got that relevant police intelligence, if the police believe that it ought to be disclosed because it's relevant to the role that a person is carrying out, they can release that information. So you're probably thinking, okay, why are you telling me about filtering rules? And one of the reasons why is because in my previous roles, I've attended meetings with social care where the police have been there and they've told us everything that has been there on a person's police national computer record. And suddenly people have gone, well, that information wasn't disclosed on a person's DBS check. And this will be because what the police have then come on to tell you, we've had to remove because of these filtering rules. So I think that just gives a little bit of context, because sometimes we're getting questions from people saying, I got a person's DBS check and there was nothing on there. Yet when I've met with the police, they've told me all about this big list of offences that have taken place. So I thought that's just a bit useful information for you. Okay. One of the things I like to always emphasize to people is a DBS check is not a pass or a fail. And I think that's one of the big misconceptions you get because, so many people will say, I'm okay because I've got a DBS check. Well, you might have a DBS check, but it may have lots of information on it that may make you an unsuitable person. But it also may have information on there, but that doesn't mean that you are not a suitable person to carry out a role. So we always say, if there is information on a DBS check, you should carry out a thorough risk assessment to decide whether that person is suitable or not for a role. So the first thing we would say you need to think about is, are they going into regulated activity? Because if they are going into regulated activity and it shows that they're barred from the workforce, this is the only time we will say you legally cannot employ them or allow them to carry out regulated activity. But also we need to think about, are there any other legal or regulatory requirements in terms of what's being disclosed? We know that some regulators will say that if you have got a certain caution or conviction, it makes you unsuitable. So please always look at what the guidance is from what your regulators when you are analysing any disclosure information. Think about the seriousness of the offence. So do you know how serious the offence was? Talk to the individual to get information and context around it. Because sometimes just seeing something in black and white doesn't give you the whole story. How old was the person when they committed the offence? Was it a long time ago? Were they really young? Were the mitigating circumstances around the crime that they committed? Is there any pattern of offending behaviour? So was this a real one-off or is it something that has been happening regularly? What were the circumstances surrounding the offending behaviour? I know in a previous role, I had a candidate who had fraud convictions on their DBS certificate. When we spoke to the person about this, they'd actually been in a coercive and controlling relationship, and their ex-partner had put their name down for loans and they defaulted on the loans. Also, their ex-partner had made them continue to claim benefits when they weren't entitled to, and they were convicted of that. So when we discussed this and we looked at the risk around it, because of the circumstances around the offending behaviour, we were able to give a more thorough risk assessment. And then also, is there evidence of rehabilitation? So have they taken courses to support improvements on mental health? Had they have counselling around substance misuse? So all things like that should be taken into account. Because like I said, a DBS check is not a pass or a fail. It helps you decide someone's suitability to do a role. Okay. So in terms of our barring, so I've spoken to you about disclosure, so the D in DBS, but again, what we really need to think about is, what is the B? What do people not know as much about? So like I said, the DBS maintains two barred lists. We have the adults barred list and the children's barred list. The list contains the names of individuals who are legally not allowed to offer to work, to seek to work, or to work in regulated activity with the relevant workforce. And again, it is also illegal for employers and organisations to knowingly allow someone who's barred from regulated activity to engage with regulated activity with the relevant workforce. So previous to DBS barred lists, we had list 99, which had records of people who've been barred from teaching and other employment in education service involving regular contact with children and young people. So by January 2006, we had what we called the List 99 crisis, and that was where it was looked at to see people on the list could have been convicted of crimes that were really outdated, such as being homosexual, extramarital affairs, things like that. So the government agreed that all future decisions shouldn't be taken by ministers, but an independent body. So therefore, the Independent Safeguarding Authority was created in 2006. So I'm sure some of you will remember that. I know I do. So its role was to assess the suitability of individuals working with vulnerable groups. And in October 2019, they became responsible to include people on a barred list. In 2012, the DBS was formed, and at that point, the barred list became as what we know them as they are today. So as of the end of December, we had just over 72,000 on the adults barred list, just over 94,000 people on the children's barred list, and just over 100,000 people on one or both of the barred lists. Just because you are barred from working with children in regulated activity, it does not necessarily mean that you'll be barred from working with adults as well, and vice versa. What we look at is what the person has been referred for. So have they been referred for harm against a child or harm against an adult? And can that harm be transferred to another workforce? So that's what we think about when we're placing them on one or both barred lists. Okay. So there are 3 different ways the DBS can receive barring referrals. So the first one is a discretionary referral. And these are referrals that are submitted directly from organisations because they have got a concern about an individual, usually within their workplace, that has harmed a child or a vulnerable adult or put a child or vulnerable adult at harm. So these referrals can come from employers, agencies, keepers of registers, supervisory authorities, anyone that they come from. We will look at them and see whether it makes the test for regulated activity and relevant harm and whether that individual should be barred. The next one we have is an auto bar, and this is where an individual has been convicted or cautioned of an offence which is set out in law as an automatic conclusion offence. And these are serious offences that are set out in law which require the DBS to bar the individual from regulated activity. So auto bar referrals need to meet the test for regulated activity. So that is the person has or will likely to engage in regulated activity in the future. And the final one is a disclosure information route. And that is when an individual is applying for an enhanced with barred list check and certain information comes up that lead us to think that this person needs to be looked at closer in terms of whether they are suitable or not to work with children or adults in regulated activity and whether it would be appropriate to bar them from working with children or regulated activity. Okay. So when we get a barring referral, we have to go through a really rigorous process to decide whether or not it would be appropriate to bar a person. A bar from the DBS is not a punishment. A bar from the DBS is to prevent harm to vulnerable groups in the future. So for a discretionary referral and a DIT referral, so the disclosure information route referral, it is a 5-stage process that can be stopped at any point. So at stage 1, we have what we call the initial case assessment, and that is where we look at, does the person who is being referred meet the test for regulated activity? So have they engaged in regulated activity in the past? Are they currently in regulated activity? Or is there evidence that they will engage in regulated activity in the future? If they do, we'll then look at, has relevant conduct occurred or can the harm test be satisfied? If it can, it'll be moved on to stage 2. And that is where we look at what is the information telling us. So at DBS, we do not investigate people. We rely on the information that people submit to us from their own investigations, their own evidence gathering, to make a decision on whether harm has occurred on the balance of probabilities. So this is the civil standard of proof. So rather than the police standard of being proven guilty beyond reasonable doubt, we look at, has something more than likely or not happened? And that is why the police or the Crown Prosecution Service may not take a case forward, or even a person may be found not guilty in court. We will still look at that information and we may still bar a person, even though it hasn't been taken further by the police or the Crown Prosecution Service. So at this point, we'll start looking at, is it appropriate to take the case further? And what we'll do is we'll assess the evidence, establish the fact, but also at this stage, we might realise that we need to go out to other organisations who may hold information about an individual to help us make our barring decision. So this is where we might write to you as social workers to ask for information that you hold. And Susie's going to talk a little bit about that later on. At stage 3, we have what we call the structured judgment process, or the SJP. At this point, we start looking at, is there a risk of harm in the future? If so, how serious is that risk? And would a barring decision be a proportionate response to that risk? If we believe it would be, what we do is we have what we call a minded to bar decision. And at the minded to bar decision, we will go out to the individual that is being referred to us to ask them to tell us why they should not be barred from regulated activity. And they have 8 weeks to tell us why they shouldn't be barred. Each individual who has been minded to bar and asked for representations will get a pack of information that we have used to make the decision to minded to bar them with, so they can see what information that we've had. We obviously will redact it to make sure that information that they should not know is not shared with them. And then obviously they have 8 weeks to make those representations. Sometimes people choose not to make a representation, and at that stage we will take it straight to stage 5, which is the barring decision. However, if people submit representations to us, how we get them in varies so much. We might get someone scribbling something on the back of an envelope, to people giving us full information with legal packs that have come with support from unions and legal professionals. But once we get representations, we then have to go back to stage 3 and reassess our structured judgment process based on what information a person has told us within their representations. So that may make us think, actually, you've given us information that now lessens the risk of future harm, so we will no longer decide that we're going to bar you. It might mean that we actually then have to go out to, again, different organisations to get more information. So it might then go back to stage 2 before it can go to stage 3. But once we've completed all that, we then move on to our final decision, where we decide, is it appropriate to bar the person based on the future risks to vulnerable groups? So if a person is barred, they can appeal to the upper tribunal within 90 days of the barring decision being made, but you can only appeal on the grounds that DBS has made a mistake on any point of law or on any finding of fact that the decision was based on. If a person is placed on the barred list, they're actually placed on the barred list for life. However, a person can request a review after a certain time has passed if they can demonstrate that they have got significant information that shows us that they are not a risk of future harm to vulnerable groups. So how long you have to wait before you can ask for a review depends on the age that you were when you were put on the barred list. If you were aged 18 or under, you can wait a year. If you were between 18 and 25, you must wait 5 years. And if you're 25 or over, it is a 10-year wait. Okay, and now I'm going to pass back to Susie, who's going to talk a little bit more about the legal duty to refer.
Lovely. Thank you very much, Cathy. Yes, so this slide sets out for you when you have a legal duty to refer to the DBS in relation to us potentially barring someone. And this is kind of quite a legally worded slide with all the kind of wording from the various pieces of legislation, but I'm going to kind of translate it for you. It means that if you employ someone as a paid member of staff or as a volunteer, and you stop them carrying out their role in regulated activity, and by that we mean kind of activity with children or vulnerable adults that's kind of set out in law. So if you stop them carrying out that role, you move them to kind of a desk job or you sack them because of safeguarding concerns, you must refer them to the DBS. So kind of simply, that is your legal duty to refer. So that is when you absolutely have to refer to us. But it's worth noting as well that you can also make a referral. As Cathy said, anyone can make a referral to us. So you need to be aware of when there is a legal duty to refer, but you also can make discretionary referrals as well. When you are in a position when you have decided that you do need to make a referral to us, my advice to you would be to use the online barring referral service. And the slide kind of sets out the key things that we need you to tell us. So obviously, to kind of send the case across to us, you will need kind of various details about the person being referred. It's helpful to have details and contact details for any other agencies that have been involved, maybe in investigating what's happened. And you will need those key details of the risk of harm or the harm that has been suffered. And there's also a point in the portal where you're asked to upload documents in support of your referral. So that could be statements, it could be investigatory reports or meeting minutes or other evidence about what has happened. It's really, really important you think about the timing. You need enough information to be able to make the referral. Think about whether you've kind of completed your investigation. Have you made a decision to remove that person from regulated activity with children or with vulnerable adults? So you kind of need to have enough information to tell us what we need to know so we can make a decision, but also you need to do it fairly quickly, do it in a timely way to prevent that further harm. And it really helps us if you make sure you complete that barring referral form as fully as possible. Key thing to remember, Cathy's touched on this as well, is that DBS don't carry out investigations. We carry out kind of a paper exercise looking at what other people provide to us. We don't, unless in very, very selected circumstances where we allow verbal representations, we don't talk to the people involved, we don't talk to the referred person, we don't talk to agencies. So you really need to include any relevant information that you hold that will help us to make an appropriate decision and a proportionate decision. And I've touched on some of the kind of material that you might want to send us. You might also want to think about victim impact statements, training and supervision records and things like that, if they kind of link to the harm that's occurred. So there's kind of a few factors to think about. If you don't have a bit of information that you think we need, if you tell us who does hold it, and we can then ask that other person or agency for it. So this slide deals with kind of the process of sharing information with us. Sometimes we need to go out to an organisation or a professional who did not make that initial referral if it seems that they hold further information which could really help with our decision. And there's a little case study later that I'm going to talk you through to give you an example of when this may happen. DBS might also write to the person or the organisation that's made the referral seeking some further information. Sometimes people are worried about sharing that information with us and worried about data protection, and it's worth noting that this is exempt from GDPR considerations, so you can legally share with us the information that we ask for. And the quicker we get that information, the quicker we can make a good decision to enhance safeguarding. So if we ask you to send information to us, we will send a letter. And in that letter that we send to you, we kind of clearly set out what information it is that we require. There will often be a kind of list of bullet points. And if you don't provide that information or don't provide it in a timely way, it can really affect our kind of capacity to carry out our safeguarding duties by making that decision. So if we ask you for information that you think you have a reasonable reason not to disclose, or if you don't hold the information that we're asking for, please come back to us quickly and tell us who does. That means that we're not waiting around for your reply unnecessarily, and we can kind of get on with seeking the information from elsewhere. So responding to us helps kind of close up those potential gaps and that ambiguity in the process of trying to gather the information. We're also keen to kind of make everyone's life easier. If we contact you, for those of you who work in local authorities, if we contact you, for example, about some information and we've come to you and you're not the correct person, there's a more appropriate point of contact or maybe a pathway in your organisation that would streamline the request, please let us know. We can update our records and make sure that we come to the correct person next time. We kind of want to work alongside you, so however we can kind of make it easier for you and easier for us to get the information that we need. And just a note here, for those of you who work maybe in child protection, you may well hold information about care proceedings or less likely, but possibly about private law children matters. And sometimes people are understandably really wary about sending that information out, are worried about being in contempt of court. Just to underline that you absolutely can send us information relating to the family court. It's there in the family procedure rules that are set out on the slide. So don't worry about disclosing that to us. You are allowed to if we ask you for it. So I'm just going to go briefly through an example to kind of set out when we might ask a local authority, by way of example, for some information about a person. So I'm going to talk to you about Lola, who is applying for an enhanced with barred lists DBS check because she wants to work as a carer for young people with learning disabilities. And on that check, the police have decided to disclose in the intelligence section that a local authority, which I'm going to call Local Authority A, has recently been involved with Lola's own children. And because this information has come up on that enhanced with barred lists check, that will cause a barring case to be created at our end. We would then write out to social workers at Local Authority A to ask about what has happened in relation to Lola's children. And that local authority comes back to us and lets us know the children were subject to PLO a couple of years ago and that they're still on child protection plans. And obviously there's lots more steps around that, as Cathy has talked through, but the process kind of culminates in Lola being placed on both barred lists. And I suppose the really important thing to underline here is that the local authority or local authority social workers are the only agency holding the entirety of this information. The police only have a snapshot. Lola's children are already being safeguarded by the local authority, but those young people that she seeks to work with would potentially be at risk if we don't get the information we need from the local authority. And the next slide sets out what happens if there are delays in providing information to us. So the slide I'm showing you now is based on a real life case. I'm going to talk first through what's happened our end and what actions have been carried out by DBS, and then look at the situation for the individual. So you can see that in this particular year, a referred person was dismissed from regulated activity with one employer. That employer did the right thing. The person was in regulated activity. They dismissed them. So they sent a referral into us at the DBS. We promptly sent out an information request letter asking the local authority to provide us with some more information. We didn't hear anything. We sent out a reminder letter towards the end of June, made some phone calls, still didn't succeed in getting the information. We did make contact with somebody in the local authority in August who understood what we were asking for and advised that the information was going to be sent to us. But then there was a little bit of a delay in getting the information to us. Through September, we continued our efforts to get information from the local authority, and we did finally receive the information that we needed in October. So you can see quite a lot of time has elapsed. If you look along the bottom of the purple line, you can see what I referred to initially, that referred person was dismissed from their role with employer one prior to April. Because of the delay in us being able to consider them for barring, they were able to get another job in July in regulated activity because they weren't barred. And later in that year, in September, there were then concerns raised by that second employer. So the key message really from this slide is that there was a 167-day delay in us getting from considering that referral for barring to getting the information that we need, which led to a person who was later barred being able to remain in regulated activity and potentially posing harm to people. So I hope that kind of illustrates why we really need to get information from yourselves and anyone we ask in a timely way. So in conclusion, I hope you can see from kind of what we have gone through that DBS is a really key part of the safeguarding infrastructure in the UK. And in terms of Social Work Week and talking to you as social workers, it's really, really important that you're aware of the levels of checks that can be carried out. You're aware of what information goes on those checks. So you're aware about the filtering rules, that not everything's on there. You've had to think about interpreting the information on checks, that you're aware of the legal duty to refer to us if you remove someone from regulated activity, and the kind of need to provide information to us when requested to do so. We're always wanting to work with agencies to help everybody understand each other's roles so that we can work together towards safer outcomes. And I'm going to bring Cathy in now, who is going to talk to you a little bit about her fantastic outreach service and share some slides which gives you some contact details for us. Thank you.
Thanks, Susie. So as Susie said, we're here to help. So the partnership team is here to support you as an organisation, as professionals, with any information that you might need about DBS products and processes. We will say, however, if you've got any questions that directly relate to things like where a check is up to, please contact the customer services team. The details are on the screen there because that's something that we don't have access to. So we will be able to support you with anything around questions around DBS checks, eligibility, regulated activity. If you think about barring referrals and you think you may have the legal duty to make a referral, but you'd need a little bit more support around that, please contact us. I will always say, once we deliver workshops, often people will go away and go, I think I maybe should have made a referral about someone. If you've got that niggling feeling, please reach out and contact us. We're never going to reprimand you or tell you off for not making a referral. We'd rather receive a referral late or historically than never at all. We can also deliver training, such as like what we've been doing today, and any workshops directly to your teams and networks. We can support any training programs that you've got that require DBS information. And also, if you get in touch with us because you've got some feedback about DBS products and services and how you think that we can improve them, please let us know. So on the screen there, you can see our team email address. I will also quickly flag up our socials. So please follow us on Facebook, Twitter or X, and also on LinkedIn on the Disclosure and Barring Service page, because we share lots of information around there as well. And I will just flag up each region has their regional outreach advisor on there. So please contact them directly and they'd be more than willing to help you. So I think that comes to the end of our presentation when we have 12 minutes left for questions. So Rennie, would you like me to stop sharing the screen and we can go to any questions?
That would be great. Thank you. First of all, thank you, Susie and Cathy. A lot of information to digest, but really interesting, and a lot of questions as well. So we did have a very active Q&A section. So the first question, sort of selfishly, coming as a social worker myself and as a regional engagement lead here at Social Work England, we know that part of the sort of employment process for social workers is getting a DBS check. And normally we get a lot of feedback that especially for newly qualified social workers trying to get on the register, that sometimes there may be a delay when with that check that sort of puts on a delay in them starting their different roles, etc. And that has a knock-on effect. So can you give any insight as to what are the sort of time frames and what are the sort of things that may cause a delay in getting that sort of DBS clearance or check?
Yeah, so for the enhanced with barred list checks, the average processing time at the moment is about 14 days. The reason why things may be delayed is with the enhanced checks, as I've said, they will go to local police forces to see whether they hold intelligence about a person. So anyone who has got a name match with anybody on the police national computer, it will go to the police force to either rule that match out or rule that match in. It may need to go to 52 police forces across the country. So as you can imagine, that's quite a big process. And then each police force needs to either say, yes, that is a person, or no, that's not the same person. If they actually are the same person and the police hold relevant police intelligence, they then have to go through what is called the quality assurance framework. And that is questions that the police ask themselves to say, is this information relevant to be disclosed? Is it in the public interest to disclose this information on a DBS check? And if they think it is, at that point, they may go out to the individual to, again, like we ask for representations for barring, they may ask an individual why it shouldn't be disclosed on a DBS check. So that can be why it takes a longer time than people would expect. We do have a service level agreement with police forces to complete any police intelligence within 60 days. If a person's DBS check is stuck at the 60-day process, so at stage 4, sorry, for more than 60 days, we would say, please contact customer services and they will look to escalate it for you. Unfortunately, we have a lot more DBS checks going to police forces than they have staff to process the information. So sometimes that can cause delays, but also other times checks get delayed because there's errors when they're submitted. For example, people have put the wrong names in, they've put the wrong workforces in. So sometimes they may get rejected and delayed at that point, but hopefully people aren't experiencing as much delays as they can do.
Really, really good. Thank you so much, Cathy, for that context, because that comes up a lot in terms of people not really knowing what goes on behind the scene and just see it as DBS check, but they're not, as you said, 52 different police forces in the background. So thanks for clarification. Another question has just come in. It's just a simple one. This one, is there a link to the definition of regulated activity? I think that should be on a DBS website somewhere. Is there any way we could guide people to?
Yeah, so if you go onto gov.uk and search for DBS eligibility guidance, it will bring you up a whole host of really useful resources and leaflets that tell you about eligibility and the definitions of regulated activity and who's in it and who's not.
All right, good. I've just had another question there. So someone said, if someone is suspended pending investigation following an allegation by a patient of assault, for example, do they need to, as an employer, does the DBS, do they need to inform the DBS, or should they be informed at the conclusion of an investigation?
So they should be informing us at the conclusion of an investigation, because if someone's suspended, you may then decide to put them back into regulated activity. However, I will caveat that sometimes a person is suspended for quite a long time due to police investigations, and that may hinder you from making a decision to dismiss a person. So if a person is suspended for a long period of time because of a police investigation, we would say reach out to your regional advisor and have a chat to them, because sometimes you may have enough information that even if there wasn't a police investigation going on, you would dismiss that person, and you could give us that information to make a decision based on the balance of probabilities.
Yeah.
However, we would always say talk to the police before you do that, because you may have information that you would give to us that the individual doesn't know and the police don't want disclosing, so that could hinder things. So yeah, just have a chat with the police force and have a chat with us. But sometimes we can make a decision without the police involvement.
Okay, good. Another question, a quick one. How long does a DBS certificate remain current?
So, under legislation, there is actually no time frame on a DBS check. So a DBS check is, there for eternity if you so desire. But we always will say, have a look at what your guidance is from your regulator, because I know regulators will say that checks need to be done every 3 months, 6 months, 12 months, 3 years. For example, if you're within the taxi workforce, they check every 6 months to make sure that your DBS check has got no changes. But we will also remind you that a DBS check is only as good at providing information as the day it's printed. So it is very much, you need to make your own safeguarding decisions around when you accept DBS checks. However, we do have the DBS update service, and that is a subscription service where people can store their DBS checks. If you're on the DBS update service and you've got a copy of the certificate that is on the update service, you can say to employers, here is my update service subscription, here is my certificate, and the update service will tell you if there has been any change in status. And if there is, we would recommend you get a new check to find out what that information is, so you can make a suitability decision based on any changes.
Thanks, Cathy. And I know before we started the session, we had a chat about it because I'm part of the update service, but we still have that sort of misinformation from employers and especially other organizations that just don't take the update service. So I find myself having to still apply for the more conventional DBS check. And I'm just wondering, is the DBS doing anything to just make, employers or other people more aware of this update service and that it can be trusted? Because I get the feeling that people think it's not a proper check if it's not they go through the conventional channels. Is any comments on that at all?
Yeah, so from our piece of work that we do within the partnership service, we're very much proactive around talking about the update service when we talk about DBS products and services. And we want to dispel that myth that having a DBS update subscription isn't as good as having a physical certificate. Yeah. It is that idea that a DBS certificate is the property of the individual, not an organisation. And, a DBS update service can reduce costs for both employers and for employees. It's free for volunteers, which is great. And also it speeds up the time, because if you're on the update service, you get an immediate decision or immediate piece of information to say whether a person's status has changed or stayed the same. And if it stayed the same, you can go and look at that original certificate and be confident that you're making an up-to-date suitability decision.
Agreed. Thanks, Susie.
Is
Thanks, Cathy.
is it worth saying there that you can use it for new employees as well? You can transfer it from one employer to another as long as it's within the same workforce. So really, really useful if you are changing jobs or if you work for multiple employees. You don't have to keep having different DBS checks.
Yeah. Thanks, Susie. A question here. I'm not sure if it's for, you guys in particular, but what is the expectation of review of DBS checks? I was in my last place of employment for 10 years and only had one check. Any views on that?
So I'll go from a legislative point of view in terms of, like I've just said, under DBS legislation, DBS checks aren't mandatory. They are there to support safer recruitment. There is no time limit on a DBS check. However, and I'll pass back to Susie to talk about the safeguarding aspect of this one.
Yeah, I'm aware since I started this role that, there's really wide variation across the different sectors about how often checks need to be done. My experience from kind of social work background in local authority and with CAFCAS is that you would check around every 3 years, which seems kind of a reasonable balance to make sure that you're not kind of over checking, but you're checking reasonably often. As Cathy said, the need for those rechecks is got rid of by the use of the update service, so that can be really useful. But it's each employer, each agency will have to make their own decisions about how often they check, but the longer you leave it, obviously the greater the safeguarding risk is created, because effectively a certificate could be out of date the day after it's issued. So we just want employers to reflect on that as part of a suite of safer recruitment, because safer recruitment's not just a DBS check, all the other things about references and employment history that we would expect employers to do as part of safer recruitment or safer employment.
Yes.
And also look at what your regulator specifies as well.
Yeah. Thank you, Susie and Cathy. A really informative and interesting session. I learned a lot from it that I didn't normally know, because you see the DBS as this sort of function, but you don't really know the functionality that sits behind it and everything else that goes on behind it. So thank you for that. Just a reminder to those who are here that the recording will be available to view shortly after Social Work Week on our YouTube channel. And we hope everyone has enjoyed today's session. I surely have, and we'd appreciate if you can complete the brief survey which we have added to the chat, and we welcome any feedback that you may have either via the form that's in the chat or by emailing socialworkweek@socialworkengland.org. And for the social workers that are on the call, this session can be used as CPD, and you could reflect on what you have learned today with a colleague, your manager, or another professional, and that will meet the requirement for a peer reflection. So that just leaves me to say thank you again to Susie and Cathy, and for everyone for joining us today. It's been a really, really great session, and enjoy the rest of your day, everyone. Bye-bye.
Thank you so much for having us. Thanks for attending, everyone.